to file an application, my lord, where the petitioners were restrained from going out of the Sobong jurisdiction of the Sobong police station. So, my lord, what happened now? My lord, they are.
It is not the mentioning date.
My lord, I'm just praying for leave, my lord. Leave.
No, file it as per present.
My lord, my lord, let me address the court. My lord, the difficulty is that if they are not allowed to go out of the Sobong police station, my lord, they cannot come to the jurisdiction of the High Court and they cannot complete the, my lord, oath or appear before the oath commissioner. My lord, they had prepared an application supported by notary affidavit. My lord, I'm just praying to file the application supported by the notary affidavit with the.
What is the urgency?
My lord, urgency is that, my lord, they are praying for they're praying for subsequent situation has arisen, and my lord, they are praying to address the court on these on such situations, my lord. My lord, just it is an innocuous prayer, my lord. I'm just praying for submitting the file the CAN application with the support of the notary affidavit, my lord.
Oh, no, but what is the urgency that it has to be done? Why with notary? Bhokalatnama you are not getting.
No, my lord. Kalatnama, my lord. The as in present situation, my lord, supported by notary affidavit, my lord, the petitioner cannot file before the Honorable High Court.
Follow the procedure. File with Bhokalatnama you file it and get it affirmed.
My lord,
the difficulty?
My lord, difficulty is that they have to be present before the oath commissioner,
Yes.
and that is beyond the jurisdiction of Sobong police station, my lord. My lord had directed to not to go beyond the jurisdiction of Sobong police station, my lord. Yes, my lord.
Now, what the application? What you are praying for?
My lord.
Relaxation of condition.
Yes, my lord.
Relaxation of condition. Now, you can any authorized person can affirm on his behalf.
My lord.
Suppose a person is in custody.
Yes, my lord.
Then any authorized person can affirm on behalf of that person. Regularly, I am getting writ petitions.
My lord, then power of attorney has to be granted. No. My lord.
Regularly, I am getting writ petitions.
My lord,
the petitioner is in custody. Now, the authorized person on his behalf can affirm.
My lord, family members can be.
Yes.
Great, my lord.
With the lordship's permission,
Mr. Das, please inform Mr. Shobbhusachi Banerjee and Mr. Billodal Bhattacharjee, because I have seen in today's newspaper, Abhishek Banerjee's one application is pending before me, seeking permission to go abroad for treatment. Now, yesterday, Honorable Supreme Court directed that matter, directed the High Court, requested the High Court to decide it by 7 days.
Lordship.
So, therefore, matter needs to be placed in the list tomorrow.
Lordship.
At the top. So, therefore, before that, I want to hear Mr. Banerjee and Mr. Bhattacharjee so that they are informed.
In that application, perhaps, Lordship, Mr. Mujumdar is appearing.
Very well. Inform Mr. Mujumdar and Mr. Shobbhusachi Banerjee that appear before this court.
Lordship.
Because if time goes in that event, this court will find it difficult to get it disposed of or dispose it of within the time fixed by the Honorable Supreme Court. So, what is in my mind that I will fix it up tomorrow at the top. So, inform both the learned counsels.
I shall inform.
Yes, immediately. Yes.
Lordship, with your lordship's permission, lordship, I filed an application for intervention because I'm the de facto complainant. I want to withdraw my case, lordship.
Mention on Monday. Why you are mentioning? Today is not a mentioning day.
Lordship, application, lordship, case application on
mention
Friday.
on Monday. Sorry, mention on Monday. Yes, please call the list.
Item number 1.
Today is not the mentioning day. There is a difficulty advocate is facing. That's why mention on Monday. That's why I have permitted to mention that matter. Mention on Monday. Unless until it is extremely urgent. Yes.
I am for the petitioner.
Yes.
I am for withdrawal this matter, Lordship. It is my written instruction.
I am for the respondent number 4. Private.
You are for the petitioner?
Yes.
Who is appearing for the state? What is the matter? Just a minute. So you are praying for proper inquiry
Yes,
and
Lordship.
arrest. Now, any criminal prosecution is
Yes,
issued
Lordship.
by drawing
The
up
case has
FIR.
already been started.
Where is the particulars of that prosecution?
Yes. Lordship, paragraph 5, page number 4.
Dated.
Dated Lordship 7
Where is
7.
where is copy of FIR? Where you have annexed it?
Yes, my lord, page 12 is the FIR,
Page 12.
page 12.
Page 12 is complaint.
Complaint.
Based on which FIR was drawn up? Where is formal FIR?
Formal FIR, formal FIR, my lord.
Do you have any instruction? Oh, you are appealing for the private respondent. Where you have stated that that particular case was initiated on the basis of complaint.
Lordship, paragraph number 4,
Paragraph 4.
page number 3.
No particulars of FIR is not there. So and so case number, so and so dated so and so under section so and so.
Lordship,
Where is that?
Para 5, para 5.
Date is not there.
Yes, Lordship.
Birampur police
Paragraph
station case
5.
number 1511 of 2025 under section so and so and
On-
so and so
On
on
7th
7th July. Yes. Now you are seeking certain directions to arrest the accused person and proper inquiry. If that is your contention, approach the jurisdictional magistrate,
Yes,
because
Lordship.
there is a judgment of the Supreme Court recent that if even after registration of FIR, party is not satisfied regarding manner of inquiry or investigation, in that event, that party needs to approach within the statutory framework.
So may I? Subsequently, Lordship, FRT has already been given to the
FRT filed.
right.
So then nothing
After
remains.
that, reinvestigation already been started.
Yes.
This is the order, Lordship.
So the investigation is started, and if it is not being appropriately done, it is not on record.
Right.
If it is not appropriately done, then I can grant court will grant you leave to approach the jurisdiction magistrate.
My lord, it is the
But the access
writ petition becomes infractuous, my lord.
Why?
Civil prayer has been made before the trial court as well as the high court. Trial court already
True.
decide the matter and directed to further investigation into further
That is
investigation.
under section 193(9). Further investigation.
Yes, ma'am.
But there is no case made out in this writ petition that you are seeking direction in connection with further investigation,
No, Lordship.
because this writ petition was filed
File February, in the month of February. Lordship.
February.
And the order passed, Lordship, July.
So subsequently, you have to withdraw the writ petition. You can file afresh if you are dissatisfied. No case is made out here. Already your case your grievance is redressed by the order passed by by Judge Special Pokso Court, Berampur, Murshidabad. So nothing remains in this matter. File your affidavit of service.
Yes, Lordship.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner by next paragraph. Petitioner by presenting this writ petition has prayed for direction upon the concerned police authorities to arrest the petitioner and to investigate the case Birampur Police Station case number 1511 of 2025, dated 7th July 2025, appropriately. Next paragraph. However, from the submissions made on behalf of the petitioner and respondent number 4, however, from the submissions made on behalf of the petitioner and respondent number 4, it appears that jurisdictional magistrate passed an order on 5th June 2026 after filing of final report by the investigating officer on completion of investigation to conduct further investigation. to conduct further investigation. In terms of section 193(9) of BNSS 2023. Next paragraph. In view of order passed by the jurisdictional magistrate on 5th June 2026, no further order need be passed on this writ petition, and the writ petition is disposed of. Next paragraph. Copy of the order dated 5th June 2026 passed by jurisdictional magistrate is taken on record. Yes, take it back. Yes. ওটা দিয়ে দাও। Next. এটা কত নম্বর ডাকলে বলো তো?
Item number 2.
My lord, I'm for the petitioner, my lord.
Yes, you want release. Yes. Matter was mentioned before. No, matter is accommodated in today's list. Matter is accommodated in the supplementary list. Since matter was mentioned, seeking hearing of the writ petition out of turn in view of urgency. Next paragraph. As this court is not satisfied with the urgency, prayer of the petitioner for hearing out of turn was not acceded to. Next paragraph. Petitioner prayed for release of the matter. Learned advocate representing the petitioner prayed for release of the matter. Next paragraph. Hence, writ petition stands released and liberty is granted to the learned advocate for the petitioner to take steps accordingly.
Item number 3.
My lord, I seek liberty from my lord to appear through virtual mode.
I am for the petition.
Well, I'm for the state, my lord. In terms of the last order, my lord.
Register করেছে?
Yes, FIR is drawn up.
My lord.
For drawing up of an FIR, writ petition,
My lord.
application under section 175(3), there was an order by the jurisdiction magistrate, and even then no steps were taken. Then this court passed an order on
Twice.
22nd July,
Yes,
then
my lord.
subsequently on 3rd of August. That means yesterday FIR was drawn. See the conduct of the police authority.
And in the meantime, my lord, I have made 5 or 6 phone calls to them. Kindly give that report. That's it. They have annexed the FIR, FIR also.
I'm disposing it off.
My lord, may I just point out one thing, my lord? Kindly permit me one thing, my lord, not on the FIR or nothing else. My lord, may I just point out one thing? My lord, kindly permit me to point out one thing, my lord, not on FIR, nothing else, my lord. On the facts of the matter, my lord, my lord, kindly take note of once paragraph 3.
I need not. This is not your writ petition. This is a writ petition of the writ petition filed by a party who was suffering in view of the order passed by the jurisdictional magistrate. No FIR is drawn up. Since FIR is drawn up, I will not enter into the merit. Sorry.
My lord, no, merit, my lord, the complaint is something else.
In terms of the order dated,
my lord, kindly permit me, my lord, once, my lord. Otherwise, I will not make
after the
any
order was
submissions.
passed by this court on 22nd July 2026, today matter is taken up for consideration in terms of the order dated 22nd July 2026. Stop. Learned petitioner and state respondents are represented by learned advocate. Respondent number 9 is represented by learned advocate on virtual mode. Next
My
paragraph.
lord, 6 to
Learned
8 and 10.
advocate
Respondent
for
number
the state.
6, 7, 8, and 10, my lordship. He is appearing for virtually, my lordship.
I am for respondent number 9.
You are for 9.
No, my lordship.
I am for 9.
Respondent number 6, 7, respondent number 6 to 9 are represented by learned advocates.
No, my lordship.
6, 7, 8 and 10.
Very well, that will be segregated by my officer.
My lordship, till 10, my lordship.
Respondent number 6 to 10 are represented by learned advocates. You are appearing for 6, 7, 8 and 10. And he is appearing for 9.
No, no, my lord. I'm leading. He is my junior in this matter.
I am for
So
respondent
you
number
are
9.
appearing for 9 and you are appearing for 6, 7, 8 and 10.
No, my lord, 6, 7, 8 and 10.
6, 7, 8 and 10 and he is for 9.
9.
Yes, respondent number 6 to 10 are represented by learned advocates. Next paragraph. Learned advocate representing the state respondent number 6 to 10 are represented by learned advocates. Stop. Next paragraph. Respondent learned advocate for the state has filed a communication dated 4th August 2026 of officer in charge Shagordegi police station, and same is taken on record. Stop. Copy of the said communication be made over to the learned advocate for the petitioner. Stop.
Copy,
Next
sir.
paragraph. Next paragraph. It is disclosed in the communication dated 4th August 2026 that FIR has been FIR is drawn up. FIR was drawn up by the concerned police authority, being Shagordigi police station, case number 469/2026, dated 3rd August 2026, under certain provisions of BNS. Next paragraph. BNS. Next paragraph. In view of steps taken by the concerned police authority, no further steps are required to be. No further order needs to be passed on this writ petition, and the writ petition stands disposed of. Parties to act on the server copy.
My
Next.
lord, the matter is pending. Lower court matter is pending tomorrow, my lord. And the
Next
date of complaint is different, my lord. That's why I was trying
Item
to
number
point
4.
out, my lord.
Item number 4, my lord, I am for the petitioner. My lord, that advocate matter, Barakpur Subdivisional Court, your lordship passed an order on 30th June 2026. 30th June 2026.
Yes.
Lordship, this is a clear case.
In the meantime, my lord, bailable section, non-bailable section was added, and the accused person was arrested and thereafter granted and bail by the jurisdictional court with some restriction. My lord, I am not on that. I am on that, my lord. Lordship
He will
kindly
be on
direct
everything after I make my
Yes.
submission, because there are certain records which needs to be brought before your Lordship.
Well, I will hear you. Yes.
Lordship.
all
Steps have been taken by the police officer.
yes, my lord. All records, all work or record with me by filing supplementary affidavit. Your lordship, if your lordship
Not
allow
required.
me, not
Steps have been
then, my
taken.
lord, kindly I am praying for during the journey from residence to court. No police protection first, and the day before yesterday, my mother was threatened by the main and agent of the my lord accused person. I lost the complaint. That is my submission. I am praying for before your lordship for only police protection now, my lord.
Yes, Lordship. He threatened the police officials. He has threatened the police officials. He has threatened the learned.
After this order was
After
passed.
this order was passed, he has threatened the learned additional chief judicial magistrate in open court, for which he has been directed to appear in court and be present in court. Lordship, he has made all the allegations that he is making are all false, which has been taken on record by the learned
There
lower
was a
court.
severe injury, page 24.
Lordship, all those injuries are absolute. I will not get into that. Police is investigating. However, he had made a complaint that that offences under the SC/ST Prevention of Atrocities Act has been made. He had provided a pen drive allegedly containing certain phone calls by which these threats and et al were made. This was produced before the learned magistrate. Lordship kindly looks at what the learned magistrate has said.
Order with me.
I will, sir. I have not interrupted. I have not interrupted when you were making submission, sir. Please.
Inform Mr. Mujumdar. Inform Mr. Mujumdar, because that matter I will place it tomorrow. That the prayer seeking
Treatment.
to go abroad. Because I have seen in today's newspaper that there was a request made by the Supreme Court to dispose it. Mr. Mujumdar is appearing, as I am told, on behalf of the state. Inform Mr. Mujumdar to come so that I can inform both of you. Yes, immediately. Immediately. Yes.
Why it is reflected from the
My
order
lord,
of the SCJ that
Just-
SCJ
just a
was
minute.
threatened.
So 3082 was subsequently added.
And that order, lordship,
That is not important, Lordship.
certified copy of that.
Kindly reads after that.
Look into the
That is what is more
certified copy of the
important.
order. Why are you shouting?
I have not interrupted you when you have made submissions, sir. You have constantly interrupted me when I have made submissions.
What asked me? Not a political platform. It's shouting. What's up?
नहीं मुझका जब ये वीडियो
Yes, steps have been taken.
I have
Various state.
stated, my lord. I have stated, my lord, all certified copy with me, my lord. Steps have been taken, but only grievance before you, my lord. I am paying for, my lord, continuation of the police protection.
But by taking advantage of the order passed by this court, further prayer was made, as it appears from the order of the jurisdictional magistrate, 12 July 2026. What is the
12 July.
conduct of the petitioner?
12 July, my lord.
Yes.
My lord, 12 July, 1759.
এটা করে 9 কি করে আসবে
12
এটা 57 এটা 57
12 July, 8/7, 11/7, 11/7.
Come to for adding sections.
12 July, order not 77. उसने आती है।
এখান থেকে আপনি বার করুন
আমারটা কপি দাও।
এটা
It was signed on 15 July by the additional chief judicial magistrate, saying that the prayer was made for addition of section 31R and 31S of Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. And it was recorded in this order by the jurisdictional magistrate that till rejected as till 12 July or the last date, no such allegation was made.
That was
So
rejected.
therefore, it appears that by taking advantage of the order passed today, passed earlier occasion, now petitioner has started to take advantage of that order.
Improve the
That this court will not tolerate.
That was rejected.
No, why this prayer was made subsequently, and the judicial magistrate has recorded in the order it was recorded. It is an afterthought. So therefore, it appears that after the order passed by the High Court, this prayer was made.
It is true, my lord. Thereafter, I made an application.
Issue.
My lord, I have two things, my lord, to place before. Kindly consider, my lord.
My lord is taken up for consideration in terms of the order dated 30th June 2026, when Mr. Suchani Das, learned additional government leader representing state respondents, has filed a communication dated 4th August 2026 of officer in charge, Gola Police Station, and same is taken on record. Copy of the said communication is made over to the learned advocate representing the petitioner and respondent number 7 to 10.
My lord, kindly, I have 2 points, my lord.
Court to dictate order.
My lord, kindly,
Hear the
then
order
my
first.
lord, kindly add
hear the
that
order
without hearing the private response.
Hear the order first, and then you pass an order. You make submission. It is disclosed in the communication dated 15 July. It is disclosed in the communication dated 4th August 2026 that after order passed by this court on 30th June 2026, Section 3082 of BNS 2023 was added. In the criminal prosecution being Gola PS case number 163/2026 dated 23rd June 2026. Stop. Accused persons were arrested. However, subsequently they were released on bail. However, on 31st July 2026, they were granted bail. Stop. However, during the period accused persons were in custody, voice samples of 2 accused persons were collected by FSL expert in presence of learned judicial magistrate, 4th Court, Barakpur, for sending the same to match for sending the same to analyze and to find out whether such voice sample is matching with the data stored in pen drive. data stored in seized pen drive, and expert opinion was sought for. Steps taken during course of investigation are also disclosed in the communication dated 4th August 2026. Next paragraph. Prayer for addition of section 3(1) within bracket, section 3 within bracket 1 within bracket small r / section 3 within bracket 1 within bracket small s of scheduled caste and scheduled tribes, castes and scheduled tribes within bracket Prevention of Atrocities close bracket Act 1989 was not allowed by the jurisdictional magistrate. Stop. In this regard, no further observation is necessary, and judicial magistrate and jurisdictional magistrate is at liberty to pass order in accordance with law. Stop. Next paragraph. In terms of the order passed by this court on 30th June 2026, it is disclosed in the communication dated 4th August 2026, 2 constables were deployed, or 2 constables have been deployed round the clock at the house of the petitioner for providing protection on and from 8 July 2026, and it is still continuing. Surveillance by police authorities by conducting patrolling is going on. Stop. Next paragraph. Concerned police authorities are directed to provide such protection for a further period of 7 days. Stop. Subsequently, police assistance shall be provided to the petitioner if occasion will arise. Now, in the event occasion arises, stop. Next paragraph. In view of steps taken by the concerned police authorities, no further order is warranted, and the writ petition stands disposed of. Yes, what you are trying to submit.
This medical report is no connection with the incident, my lord.
Have I made any
no.
observation?
This is this, my lord. This is why I am grateful. Lord.
Yes, Mr. Bhattacharya, have you
I'm
informed?
informed. I'm told that he's on his legs. Will be available around 12:30, my lord.
My lord, so
Come
I'm
back at-
requesting for a passover. I'm requesting for a passover.
Well, this was the matter, my lord. No, I think
Item number 5.
something else
5.
which I have communicated to his lordship. Now, 5, my dear friend, wants, my lord, accommodation where, my lord, there is a brazen violation.
Bhattacharya, that matter, where the petitioner is praying, this for traveling abroad
Your lordship is right, my lord.
for administering treatment. There I find in today's newspaper that there's a direction by
Your
the
lordship is right, my lord.
Honorable Supreme Court directing the High Court,
Requesting the, my lord, requesting.
requesting the High Court to conclude hearing of that application within 7 days. So time is less. Tomorrow it will be at the top of the list.
Please, my lord.
So therefore,
We'll come
be
prepared, my lord.
informed, and also inform Mr. Mojumdar and ask Mr. Mojumdar to come so that court can convey this.
Very well, my lord. I have already informed him, my lord. Again, my lord, when he will be there.
And inform members of your team.
Yes, my lord. I will do that. Because I am last in the line, my lord.
Yes.
And by default, sometimes I get the chance, my lord, and the
You are very
privilege.
much in the line at the front. Yes.
The privilege to
There
address
is
your lordship.
nothing in this regard because I thought
No, your lordship is absolutely right,
putting
my lord.
this matter in the list, it would the learned advocate should be
I'm
informed.
deeply obliged for that, my lord.
Yes. Yes.
My lord, there is a brazen violation of your lordship's directives, my lord. My
We are
lord,
praying for time. On
Lord,
whose ground?
I'm requesting for a passover. We are led by Mr. Majumdar. He's on legs in court number 37.
Then not today, Mr. Bhattacharya. Today, this court has difficulty in the second term.
my lord, he will be available at 12:30, my lord.
Well, let it remain in the list. It will retain its position.
It will retain its position. Obliged.
Item number 6.
I'm for the petition, my lord.
My lord, I am for the statement.
I'm for the private respondent.
Yes, what is the instruction whether cognizance of offence is taken?
Yes, ma'am.
Well, last 25 years, creating pressure upon the petitioner. Handed over the entire power. He's the son of
the case made out after cognizance is taken, because there is an intervention by the by judicial order which ought not to be gone into in a writ petition.
Only one line order, not to interfere my life and my daughter's life.
No, that I cannot.
Always creating pressure to hand it over the property. 76 years old, my lord. When my lord, the mother filed the case against the my lord, her son, my lord. Sometime construction made without sanction plan.
15 July 2026, cognizance taken.
Only only order.
In terms of the
Not to
order
interfere,
dated
my lord.
19 June 2026, officer in charge. And in terms of the order passed by this court on 19 June 2026, a communication dated 4th August 2026 is filed on behalf of the concerned police authorities and same is taken on record. Next paragraph, it is disclosed in the communication that in Lilua police station case number 158/2026 dated 8 April 2026, charge sheet dated after filing of charge sheet dated 30 April 2026, cognizance was taken by the learned judicial magistrate Howrah on 15 July 2026. Next paragraph. Since cognizance of offence is taken by the jurisdictional magistrate after filing of charge sheet, writ petition is not maintainable in view of a judicial order passed by court below. Stop. In this regard, reliance is placed on the judgment of judgment of the Honorable Supreme Court reported in 2024 SCC Online SC 5761, Nita Singh and others versus State of Uttar Pradesh. Next paragraph, it needs to be recorded herein that petitioner is court is not considering application, court is not considering petition court is not considering petition under Article 227 of Constitution. Neither this is an application under Section 482, Section 482 CRPC / Section 528 BNSS. Stop. Once once judicial order intervenes in a proceeding, writ petition under Article 226 is not maintainable. Stop. Hence, present writ petition is not entertained and same stands dismissed. However, this order shall not preclude the petitioner to approach appropriate forum.
Much
Okay.
much of
Well, one line or
Great.
Item number 7.
My lord, in this matter, I have both takes, my lord. But I want to file a supplementary affidavit, my lord. And I used to file a supplementary affidavit. And after the filing of the writ petition, I was brutally assaulted and my right leg has been broken and I was hospitalized.
No, I have not granted any leave to file supplementary affidavit. Sorry.
Leave may be granted.
No, I am not granting any leave. Sorry.
Lordship, I am for the private respondent number
Satisfy
5.
me. At the time of call,
So that the reporter copy did not. The reporter copy.
Yes, what is the matter about?
Matter that I am a owner of a medical shop. And my lord, I have every document to show that I am an owner. And after the state assembly election, I was the subject matter of forceful violence, and my shop has been taken care by the private respondent. And thereafter, I am when I filed this writ petition, they assault me brutally, and I was hospitalized. Till yesterday, I was released from the hospital, and my right leg has been fractured, and I have been installed a plate. This is the entire condition of my.
Your right leg was fractured
and I was hospitalized. I was undergone operation, and thereafter in my leg there is a installation of the plate, titanium plate. It has been installed. This is the entire situation. I want to restore my shop. This is my
restore your shop means?
Well, my shop which has been taken care by the members of the other political parties after the post-poll violence.
So your shop was encroached by the members of the political party?
Yes, my lord.
Where is your complaint?
My complaint is at page number 63 onwards.
Yes, what is your instruction? Any FIR is registered?
FIR was registered prior to that, my lord. That has I have annexed. Page number 46.
Two complaints were registered, my lord. Case number 76. And the
Page
section-
number?
Page number 2, my lord. On 7/5/2026, the petitioner sent a complaint through the email with annex here too. As per the Bharatiya Nya Sanghati, on the basis of the email complaint, having no signature, no FIR can be registered, the petitioner was asked to come to the police station.
So there is a settlement. No, yes, police is saying in between petitioner and the
I was taken
and the local persons against whom you lodged complaint.
My lord, that has not been
And there is another complaint by the by one person, namely namely one Chandan Shikhar Jadhav. Chandan Shikhar Jadhav.
Chandrasekhar Jadhav, I have seen.
Chandan Shikhar Jadhav.
After filing of this writ petition, I came to know, my lord, but there is no settlement. There is a settlement by and between the parties.
It is stated that there is a settlement amicably, and he also mentioned in the letter that he did not have any complaint against anyone.
Well,
Where is
there
that letter? Where is that letter?
Letter has not been annexed, my lord.
But you have referred to one letter.
Well, I was
come to page 2, last 2 lines.
Well, after filing of this writ petition, I was asked to come, and I was
amicably, and he has received all medical stocks and all other articles.
My lord, I've
Then read it. He also mentioned in the letter that he did not have any complaint against anyone.
Yes, my lord.
Where is that letter?
That letter has not been annexed to the report. I'll ask for the report.
Produce that letter. Today, today on behalf
Lordship, I am for the
of
private respondent number 5.
dated 19 July 2026 of officer in charge Fulbagal police station is placed before this court and same is taken on the next paragraph. It is disclosed in the communication that in connection with Fulbagan PS case number 84 dated 21st May 2026. There was settlement between the parties and a letter was submitted. Full बोल बुझले. In connection with Fulbagan police station case number 76 dated 11th May 2026. 76 dated 11th May 2026. There was settlement between the parties and a letter was submitted by the petitioner to that extent. However, letter of the petitioner relating to settlement of dispute is not produced before this court. Next paragraph, officer in charge, Fulbagan police station being respondent number
4. Correct 4.
is directed to produce a further a report. Is directed to file further report, including disclosing the letter of the petitioner by which dispute was settled by 7 days from date. Next paragraph, list the matter under the heading motion, new motion 1 on 25th August 2026.
I will be allowed to file a supplementary affidavit.
No. No, sorry.
Item number 8.
Your Lordship was looking for me.
Yes, Mr. Mojumdar, that
I know, my lord, yesterday the matter was heard before the Supreme Court.
I
Supreme Court
noticed in the newspaper that there was a request made by the Supreme Court.
Yes, within 7
directly,
days.
so that application can be disposed of by 7 days.
7 days. Yes.
Now, application day is on Friday. If I take up this application, if this application hearing continues, then
Kindly take up this matter day after tomorrow.
no, tomorrow at the top.
Tomorrow?
Tomorrow
As
at
your
the top.
Lordship desire.
Yes.
Condor will, my lord, appear with me. Tomorrow, your Lordship.
Tomorrow it will be at the
Yes,
top.
yes.
I have also informed Mr. Bhattacharya representing the petition.
I do not know why they went to Supreme Court. All my
Very
matter was
well,
pending.
since there is a request comes from
ultimately it was.
a request comes from the Supreme Court, the
Yes,
matter has to be taken up.
Yes.
I was there in the hearing virtually.
Yes. And produce that order of the
Yes,
Supreme
yes,
Court.
definitely, my lord, definitely.
That application will be tomorrow at the top of the list.
Lordship. Myself and Mr. Mondal.
Yes, yes. If all of a sudden this matter comes tomorrow, then you will be in difficulty. All learned advocates representing the parties. That's why I thought it fit to inform the learned advocates. Next.
Item number 8.
Item number 8, your lordship is directed to file a report, independent report by the Commissionerate of Bidhannagar. In the meantime, Commissionerate has been changed. Kindly give 1 week time. Next week, any day.
We have interim order.
By interim order till 17.
Filed a can for extension. Keep
7
1 week hence.
If 1 week hence, in the meantime, it will be disposed of.
That
17, yes. Messy matter.
Where I directed
Yes,
the Commissioner
yes,
of Police to
yes.
file and to cause an independent inquiry and file a report.
Yes.
In the meantime,
With regard to fiasco.
Yes, yes.
And the incident which took place
Yes,
on the
yes.
particular day.
Yes. Only 1 week time.
in the meantime, I have complied with the direction thrice. I have met the police thrice. A MAT has been filed against your lordship's interim order by the de facto complainant or the respondent number 5. That is yet to be decided.
That is still running in the list.
That is pending. My lord, because of the fact that whether the Ramkishan Fauji judgment will be applicable to the appeal or not, on that point,
it has been heard.
It has been heard twice. It is next fixed on 28th August. But that is against the interim order, my lord. My lord may very well take it. There is no stay. The de facto is.
I appear for the de facto complaint, my lord. There's no stay. We have preferred an appeal. However, there's no stay, my lord. Next date is on 20th.
Kindly fixed on next week.
Matter is taken up for consideration in presence of the learned advocates representing parties. Mr. Mondal, Mr. Kollol Mondal, learned public prosecutor representing state respondents. has prayed for extension of time to file report by whom?
Yes, by the commissioner of Vidhannagar. Vidhannagar Commissioner.
One is direction upon Director General and Inspector General of Police West Bengal, DPIG.
Yes.
And there is another direction upon.
Yes, so far progress and status.
দুটোরই নিয়ে নাও একসঙ্গে। Now you want extension of time so far report to be filed by the Commissioner of Police.
All report. Next.
2 reports are required to be filed.
Yes, madam. The lordship is
In
absolutely.
terms of paragraph 28 and paragraph 32 of that order. আচ্ছা কি বললো? Reports. To file reports in terms of the order dated 10 June 2026.
এই দুটো কমিউনিকেট করবে 28 আর 32 অফিস এজির অফিস থেকে করা।
Stop.
বুঝেছেন? আজকেই
Time to file report by Director General and Inspector General of Police West Bengal and Commissioner of Police Vidhannagar Police Commissionerate stands extended by 7 days. Stop. Interim order exists up to which date?
17th of August.
17th August.
There is time.
Next paragraph lists the matter under the same heading for further consideration on 11th August 20.
আচ্ছা গেট আমি করে দিচ্ছি grateful.
Item number 9.
9, my lord, I am for the petition. I am not pressing this application. I am not pressing this application.
You are not pressing this application.
The grievances has been.
At the time of call, learned advocate representing petitioner submits on instruction that petition is not pressed. You are for the state, Mr. Das. State respondents are represented by Mr. Das, learned additional government period. Next paragraph. In view of such submission made on behalf of the petitioner, writ petition is dismissed as not being pressed. Parties to act on the server copy. Next. এই এসিটা পেছনে চালিয়ে দিন।
Item number 10.
My lord, I am for the petitioner, my lord. In this matter, my lord was pleased to pass an order on 13 July 2026.
Just a minute. A report comes from Registrar General Justice. Okay.
Actually, judicial ফাইলটা দাও। না এটা জুডিশিয়াল ম্যাজিস্ট্রেট।
Yes, what is the present position?
The
Regarding
judicial
judicial
inquiry has been completed. This is the report of, this is confidential, so it is in the sealed cover. And these are the documents relied upon by the learned judicial magistrate on prepare the report.
This is the report.
And these are the relied upon documents. I have the FSL report separate.
See, this report says that there is no atrocity so far police is concerned. Only two defects are there. One is with regard to preparation of arrest memo and uh, formalities which are required to be complied with at the time of taking the petitioner into custody. There were certain deficiencies found, and during there is preservation of CCTV footage when petitioner was kept, when deceased was kept in the custody, but during interrogation CCTV footage is not there, but medical report suggests that there is no foul play.
There is
Because medical report says
no foreign body.
Medical evidence consistently establishes that a deceased died of cerebral compression consequent upon a spontaneous hemorrhagic cerebrovascular accident.
This may happen, Lordship, by beating.
So therefore, the report is provided. Let it be written on record. Let me dispose it of. You take steps in accordance with law.
And unless I get the report, my lord, I cannot.
That how can it be? Then you have to approach the
Otherwise, I cannot,
because
Lordship.
it was this accordingly this report is submitted to the learned additional chief judicial magistrate Bosirhat. I will grant you leave to approach the additional chief judicial magistrate Bosirhat for obtaining report.
Your Lordship may hand over a copy of the
No.
report to us.
Because this report is furnished, prepared by the, I have recorded in my order that additional chief judicial magistrate Bosirhat in compliance with the relevant guidelines. It is also disclosed in the said communication that judicial inquiry is pending and such paid is made. Just a minute.
Whether it is a
In your
judicial
decision-
inquiry or
Judicial inquiry. It is a judicial inquiry. Learned judicial magistrate first additional court Bosirhat is entrusted with the responsibility to conduct such inquiry as per guideline. So therefore, you approach. I am granting you leave to approach additional chief judicial magistrate before whom this report is to be placed, and if you are entitled to get the copy in terms of the relevant guidelines, that will be provided to you.
that is one aspect, my lord. What
I have called for a report to in order to satisfy my conscience. But the report prima facie suggests that there is no foul play.
Only one thing, your Lordship has.
I'm telling you that there are two aspects. There are two weaknesses which are or two lacunae which are indicated in the report. One is with regard to procedural lapse at the time of arrest and preservation of CCTV footage during interrogation. But medical report suggests that there is no foul play.
But Lordship, what has happened, Lordship, your Lordship has read one line that there is a compression, that that was due to the cause of the effect of the compression in the brain. Now, Lordship, what I was reading, Lordship, I don't know whether
because this is a report under section 196.
Yes.
So report under section 196 of BNSS.
196 to 1,000.
Deals with the procedure, how to that the steps to be taken for preparation of such.
Yes, but my lord, now I will be placing it before your lordship dispose it. I want to indicate one thing, my lord. Your lordship has suggested that medical report nothing was found, contrary to the observation.
I am not suggesting.
No, it is reflected
as per report.
My lord, what has happened? There is a mention in the postmortem also that is subarachnoid hemorrhage. Now,
Very well, Mr. Chatterjee, let it be there in the on record. But I am granting you leave to approach the this Chief Judicial Magistrate, learned additional Chief Judicial Magistrate Bosirhat for obtaining the report. But if that is permissible as per guidelines.
But the only thing is that I have prayed for the investigation by an independent agency in this petition, writ petition. Today, if your lordship sends me back, and if I find that still there are the elements to argue a case of transfer, then my lord, this petition may act as a res judicata. My lord, kindly deal with that also. Then I can go.
If you pray for transfer of investigation
in future,
then
that
issue will be kept open at the time of disposing of this petition.
Kindly keep it.
Report by a judicial magistrate.
And regarding illegal detention and lordship, that 41A.
Illegal
These two are
detention, illegal detention is.
No, it says that my lord,
Family members refused. I have a specific case
Says
that
that arrest of deceased in consideration of proceeded police station case number so and so is established. Although the arrest memo suffered from procedural
whether the 35 notice
regarding attestation and recording of refusal by relatives, the evidence does not establish illegal arrest or unauthorized detention.
Well, only one thing, Lord, the 35 notice was given.
In terms of the order dated 13 July 2026.
Only one thing,
taken up
notice was given and not.
Matter is taken up for consideration when a report of Registrar General dated 20 July 2026 is placed before this court and same is produced and taken on record. Next paragraph. Mr. Das, learned additional government period representing the state respondents, files a report in a sealed cover Now, files report of judicial inquiry under section 196 of DNSS 2023, dated 31st July 2026, in a sealed cover, and same is perused and taken on record. Next paragraph. Mr. Chatterjee, learned, I am not making any observation with regard to report, because that may affect the further proceedings. So it will be better. It should not be recorded.
Only one thing.
Next paragraph. Mr. Chatterjee, learned advocate representing the petitioner, prays for supply of report. Supply of aforesaid report dated 31st July 2026. Stop. Next paragraph. It needs to be recorded herein that in order to satisfy consents of this court, this report is called for and is taken on record. And taken on record, report is also and taken on record. Next paragraph. If petitioner is desirous to obtain copy of the report, comma, leave is granted to the petitioner to approach learned additional Chief Judicial Magistrate Bosirhat stop. If prayer is made for supply of report to the petitioner, same shall be decided by the learned additional Chief Judicial Magistrate Bosirhat in accordance with law and in terms of the relevant guidelines. Next paragraph. However, this order shall not preclude the petitioner to approach appropriate forum if occasions arises.
So far, the prayers made in the writ petition. Otherwise, Lordship raised.
Then I have to take an affidavit, Lordship, because my specific case is that.
Regarding the transfer of the investigation, my lord, your lordship, my writ petition was for the transfer of investigation to an independent agency. Today, your lordship,
it is also recorded the transfer of investigation as prayed for in this is kept open. Let them come back, because in custodial death, it should not be under the aegis of officer in charge of that police station.
Definitely, Lordship, I am.
There are order judgments of the Supreme Court. If it is a custodial death, then it should not be under the.
No, Lordship, that is not the case. That is the reason a judicial inquiry was conducted, because UD case is not converted into FIR. If something
there are steps to be taken in terms of on the basis of this report dated 31st July 2026. If petitioner has any grievance, he has subsequently, if it is found that there are lacunae in the investigation, in that event, petitioner has right. Once I dispose of the petition without keeping this point open, then the problem may arise.
Lordship, it is not about the investigation; it's about the inquiry.
And it is not adversarial litigation, Mr. Das, since it is a case of custodial.
Only point I raised was that Mr. Chatterjee raised the point that the detention was illegal. My specific case is that the family members refused to sign the arrest memo. So only on that point,
there is a point where 35 notice was not given. Let them show this.
That is the only point I have taken. No adversarial litigation at all.
This is evidence you have submitted.
Yes. The documents which have been relied upon to form the judicial inquiry.
Report dated 31st July 2026. Prepared based on judicial inquiry by Judicial Magistrate First Court Bosirhat, and supporting documents shall be retained on record in sealed cover. It is sealed cover করে রেখে দেব। Sealed cover করে দুটো আলাদা করে রেখে দেব। Next paragraph, writ petition stands disposed of. এইটা রিপোর্টটা হচ্ছে রেজিস্টার জেনারেল। এইগুলো ওদের হ্যাঁ, থাক ওটা খোলার দরকার নেই। হ্যাঁ পরে সেট করুন, কাউকে দিও না, দেখতে রিসেসে করে নিন। ইয়েস, কল দ্য রিস।
Item number 11. Lordship, item number 11, there is already a civil suit which has been filed. Acha.
STO code. No, this is not a civil suit, my lord. This was, my lord, not within my knowledge, my lord. This has been filed after, my lord, the.
Just a minute.
Yes, yes. SDO একটা ব্ল্যাঙ্ক এ করে দিয়েছে যে স্ট্যাটাস কো মেইনটেইন করবে, ওটা 144 করেছে।
আমাকে এটাতে এজি সাহেব আছে, আমাকে এজি সাহেব
এজি সাহেব আছে,
এজি সাহেব আছে, জিপি
তাই
হ্যাঁ
23 তারিখ। হুম। নাম্বার দিইনি।
Last occasion on behalf of the state respondents, it was submitted that there was an order of status quo.
Yes, my lord. I have
Passed by civil court.
not a civil court, my lord. Kindly see, my lord, I have handed it over. My lord, this has been, my lord, done, my lord, after, my lord, this, kindly see the first page, my lord. There is a stray sentence, my lord, under 144, my lord, now 144, my lord. If your lordship kindly see, my lord, the fourth paragraph, being satisfied with the materials on record, my lord had found it, my lord, on record with a view of preserving public tranquility and maintaining law and order, the order of status quo already in force has been extended till 19th August. Both the parties are directed to maintain status quo strictly until further.
That is in 144 proceedings.
144 proceedings, well, he is passing status quo.
Yes.
But this is a Millard tea garden. Now, Millard, problem is, Millard, we are the Millard directors, owners. Some Millard, these private respondents, Millard, being the goons, Millard, and local inhabitants, Millard, they are camping, Millard, just Millard on the front of the Millard tea garden. We cannot enter. Millard, our Millard office has been ransacked. We cannot Millard conduct our business at all. Millard, this is the whole difficulty.
Yes, Mr. Das.
My lord, learned government pleader is leading me in this matter. He has asked me to appear. I have no report or anything.
Going on from 17th of
My
June.
lord, kindly he takes it up tomorrow. Kindly makes it not today.
Very
I will.
No instruction.
I do not have the instruction. The instruction is with the learned government pleader.
I take inception.
I was told that there is.
I will very well let the instruction written. Are you aware of that? Any communication is forwarded to
No,
the
lordship. I am not. I have been requested to.
simply not today. It will written disposition.
ঠিক আছে আমি জিপি সাহেবের সাথে
Because instruction so far the state police authorities are police authorities is concerned is required. Otherwise, it will be difficult. Yes, not today.
Grateful.
I'm not filing for that. Yes, no, I'm not.
Item number 12.
Item number 12, my lord, I appear for the de facto complainant.
Your lordships was pleased to grant me liberty. If your lordships can recollect the case, this is a matter of lottery. Supplementary দাদা সরি আরবি করোনি সরি কলকাতায় ছিলাম
Yes.
If your lordship can recollect, this is there actually two cases. One has been filed in 2024 that has been closed. After that, a new case has been formed. Your lordship was pleased to direct me to include the documents of 624 of 24 with a supplementary affidavit as per your lordship's instruction. I am doing it. And lordship, one more development in this case in between, there is one of the co-accused has been granted bail by the learned session court, and there is a finding in para 10, 11 and 12. Just go through once.
Purpose of granting bail is one thing.
No, lordship, just
and the issue which is before me, wherein
it is different.
Wherein you are praying for is
Quashing.
of criminal prosecution is consideration is completely different. So therefore, you independently don't being swayed by the observation made by the coordinate bench. You place your case.
I'm not on that
What
lordship.
is the matter?
Matter is one case has been filed.
Have you filed any pre-arrest bail application?
It is pending.
That
It was listed
is-
yesterday. It was
Yesterday
read
that has
before
been
session,
heard,
sir.
and pursuant to your lordship's matter is pending on today. The learned court was pleased to fix it day after.
Very well. Approach the PRS bill matter. Both the
No,
proceedings
lordship,
cannot be,
lordship,
cannot
lordship,
be
there is a direction of Honorable Supreme Court that one case during pendency of one case, that case has not been closed. On the self-same cause of action, second case cannot be reopened.
Absolutely. Lordship, now if my learned senior friend has submitted, may I kindly praise the 164 statement or 183 under this new provision and what the complainant has said and how that previous case got to be compromised. And presently, there is no order of the learned judicial magistrate that the compromise has been given effect to. Kindly.
The question is that person was threatened to compromise or not. That gives a new cause of
I have
action.
raised the 164 statement, sir. Please.
Whether it reflects that a person has been threatened to compromise because he was an MLA at that point of time. Powerful, influential person.
I know. Wait.
First complaint was lodged by the
husband of the complainant. Now,
and now wife
wife has lodged the complaint. Now there is another aspect to it also, Lordship. In the first complaint, the FIR named accused was only 1%.
This is a statement under section
183 of BNSS.
or before judicial magistrate.
Before judicial magistrate. And Lordship, if he's trying to make out a today case of double jeopardy, then the person who is making that case out, he also ought to have been a FIR named accused in the first FIR. In the first FIR, from the supplementary affidavit, page 9 of the supplementary affidavit, my lord kindly takes the pain to look at it. My lord has got it, Lordship. Details of accused persons, only one, Shushanto Shaha, who is the accused number 6 in this present FIR. So he today cannot take a plea of double jeopardy. At best, Shushanto Shaha could have taken, but in view of the statements made under section 164, akin to 183 of BNSS, that also perhaps will not lie today.
Yes, one Sushanto Shah.
Only Shushanto Shah.
He is accused
Number 6 here. Kindly looks at the conduct. He goes to during the 2024 period, he was shadowed by these people in the court premises.
Question is how
And
much
today he
influence,
comes
my lord,
up
this person
with a
has made in
prayer
this
and tries
case.
to gain sympathy of this honorable court. Take the justice system for a ride.
May I please your lordship?
Yes, my lord, investigation should continue because he was an influential person.
Just peruse one line.
Extraordinary jurisdiction.
Yes, lordship, there are reasons.
Shield the accused.
Lordship, there are reasons. Lordship, just
It
peruse
involves
the
1
judgment
crore
I've given.
rupees lottery, 1 crore rupees lottery.
Para 10,
my lord.
11 and 12 of the judgment I have given. Not that one, the judgment one. This document.
London Sessions Judge ordered the judgment, not order.
Hey, order passed by
What
the.
value does it have before the Honorable High Court?
At the time of granting anticipatory bail.
No.
At the time of granting bail or anticipatory
Bail. Just peruse 3 paragraphs and thereafter I will start my
My
argument.
lord, peruse it only has persuasive value.
Bail and anticipatory
Lordship,
bail
there
both
is
have a
Trying to place
different
an
footing.
order of the Learned Sessions Judge before the Honorable High Court.
In this case, in this criminal prosecution, accused number 6 has obtained bail.
Not several accused has obtained bail.
In this case.
In this case.
So let him
Several
surrender.
accused has obtained bail. Lordship, just
Bail and
peruse
pre-arrest
this.
bail is a different footing.
Lordship,
Why you have not filed bail? You are not arrested.
Not in this
Lordship,
case.
Therefore, file pre-arrest bail
No,
application that is
Lordship,
pending before the coordinate bail.
Let him.
Lordship, just I am perusing
Yesterday
one
he
thing.
took time before the Learned Sessions Judge.
No, I
His
didn't
client
take
took
time. Learned Court has stated that
After submissions made by his client's
you were
learned
not
advocate.
there, my friend. I was there.
My officer was there
Yes,
with the case diary.
Lordship, just peruse the order passed by the Learned Session Court once.
Where court will find it?
Lordship,
Where it is annexed?
it is not
Order
annexed.
of-
I have given. It is a subsequent development. Yes, that one. Para 10, 11 and 12. And that has been passed after this 164 statement submitted by my learned friend. ওরে হয় না এটা শুটিং হয় না
একটা কপি দিন না, আমরা কপিটা পাইনি।
কোন কোটার অর্ডার এটা? অ্যান্টিসিপেটরি বিল।
না, এটা অ্যান্টিসিপেটরি না।
439
সেশন কোড
439 তার মানে কাস্টাডিতে ছিল।
এটা অন্য আসামি।
হ্যাঁ তো
বেল বেল
কাস্টাডিতে তো ছিল।
ফাইন্ডিংস অফ দ্য
তুমি
কোর্টটা
বলেছিলে
দেখো।
কাস্টাডিতে নেই কেউ।
আমি কোর্টের ফাইন্ডিংসটা দেখতে বলছি। ফোন করে যাচ্ছে পাঁচজন। এটা ফোন করেই যাচ্ছে। বাবা মারা গেছে। হ্যাঁ, কে চাইছে দিয়ে দে। দিয়ে দে।
Yes,
May I distinguish it then now, Lordship?
Yes.
My Lordship. Kindly, he has in his supplementary affidavit, he has annexed all the orders passed in the earlier FIR, earlier GR case. Kindly takes the last order at page 8, which has been passed in that case. Compromise petition has been filed. Nowhere in the order, page 8 of the supplementary affidavit filed today. The last order says, seen the prayer of IO who prays for copy, supplied the copy of the statement recording under 183 BNSS of the witness. Prayer of IO is allowed. Lordship, the handwritten portion later.
Yes.
Lordship, so the learned court below has not taken cognizance of that yet. So what he's relying upon today, because in the in paragraph 12 of the learned sessions judge's order, relying on Pramod Kumar, it is said, upon presentation of such an application, the magistrate is required to independently apply the judicial mind to the specific facts, circumstances, and underlying grounds demonstrated by the investigating agency before granting or denying permission to withdraw or close the case under compounding.
Exactly, that is my case, my lord.
That is his case.
Before
Let him
close up-
approach the learned sessions judge for anticipate pre-arrest bail and let him
Not
thrash it out there.
pre-arrest. It is question of maintainability of initiation of the second case.
I will file affidavits. Let
him.
My lord, then my lord, I also have to give affidavit, my lord. In this
Let him,
regard, my
But
lord, I will also give
no
affidavit.
orders from this honorable court is warranted.
No, it is required.
And my question of maintainability be kept open.
So it is submitted that unless and until there is an order by the magistrate or the court, the issue cannot be revived.
Issue cannot. Maybe.
In reference to Pramod Kumar's ratio.
Yes, Lord,
And
here it is the
if
judgment.
the affidavit of compromise is also given, that affidavit also has to be taken cognizance, and the case GR case has to be closed. There has to be a finality to the proceeding. So subject to correction, Lordship, today also that finality has not been reached. Let him take steps before in that case also, so that the learned magistrate passes an order.
I am not a party to that case.
He accepted.
So
He accepts it. Then
Lordship,
what case? How can he rely on that case
One
at
sec.
all?
This order was passed on an application on an and pre-arrest bail application.
No, Lordship, this is a
Bail
439 application. It was in
petitioner was
custody.
in custody.
Custody,
another.
not
That-
petitioner, some other accused.
Other petition.
accused person.
Yes.
Now here petitioner has filed an pre-arrest bail application.
Bail application
Yes,
before the London
court
Sessions
and
Judge.
everything.
Before the London Sessions Judge.
No,
Sessions
London
judge.
Session Judge.
Sessions judge. Then you
No,
pursue
Lordship.
your remedy.
Let him show this before the
Carried
session,
out.
London Sessions Judge.
To pursue your remedy
Lordship.
and place this order passed by the additional sessions judge first court at the time of moving your pre-arrest bail application.
Lordship, may I
Why
submit one thing?
writ
This
court
is
will
not my
interfere
cause of
at this
action. My cause of action is during pendency of one case, if pursuant to 2001 Supreme Court, there is a judgment in TT Antony's case that if any second case has to be initiated, then police could have made an application under 173 subclause 8 before the learned magistrate on the earlier case. In this case, they have not done it. This is the
People were not
judgment
even
of Supreme Court in
accused
this
in
point.
that FIR.
Second case is impermissible.
Exactly.
As against
And I am here before your lordship for quashing of the second case. They can make me party in the earlier proceeding by making it reopening it. They could have reopened the earlier proceeding.
Second case has been initiated based on the complaint lodged by another person.
But in the
Yes.
self-same PS lordship, PS was informed with the earlier case. This 1 crore rupees has already been taken out by
My lord, the question of
petitioner,
investigation.
the defective complainants party. Now, after 25th, Lordship, there is one more thing. That is on 25th, in Nirvaya case, we could not be framed. Before His Lordship's Honorable Justice Tirthakar Ghosh, sitting with, led by Justice Shompa Sarkar. In that case, we will not be able, they could not frame me. And on 25th, 6th, this has gone. On 26th, this FIR has been lodged. Let this be permissible in the eye of law, Lordship.
My lord, there are two different cause of
Perhaps
action.
in a writ petition
First-
at least, cannot be used by a person against whom such an allegation is there that his men shadowed a person when he has gone to give a compromise petition. This
My lord,
cannot, he
two
cannot
different
claim that.
cause of action because
just one, the
compromise
high prerogative
petition,
jurisdiction.
question of
Supreme
investigation,
Court
whether he
says
was
that
forced to
one
compromise or not.
pursuant to- In an old case, 173(8), there is provision. Superseding that, how police could initiate a second case.
Basis a
That is
complaint
my
of
case.
someone else.
My lord, police can. My lord,
No,
because
they
my lord,
cannot.
the
By a
investigation,
different person against the
investigation
system of
also
law.
have to see
Well,
whether the
someone who
previous
has
withdrawal
superseded all
was under
systems
the
of law
threat of this particular
could be
person or not.
compromised.
Investigation, procedural or further investigation under section 173 subclause 8 is there in CRPC.
Now taking note of the submission made on behalf of the petitioner, how the second complaint is maintainable.
Exactly.
Lordship, firstly, today
On the same cause of action.
today the writ petitioner are not the persons who were FIR named accused in the first FIR. This is accepted, Lordship. This is an admitted position. He's making out.
We could have been made
Allow
the party.
him. What is
Achha,
going on?
Lordship. About.
He's making out a case of double jeopardy. Double jeopardy is where I have been arraigned as an
If
accused
you would have been framed in
in
or
the
if
first
you are
case,
one of the accused person
accused in the
previous
first
case.
previous case by the same person. There are three conditions. Not cause of action is not the only condition. For a double jeopardy case to be made out, there are three conditions. Me being an accused person in the first FIR, complaint being registered by the same person, and the cause of action also being the same. Over here, only one condition is relying on. What about the other two conditions? The other two conditions are not being met here. The other two conditions arose, and it is an admitted position in view of the statements that he has made, the complainant has made, that the petitioners today, both the petitioners, they were influential persons, and the complainant's husband was threatened, and he was taken to a place. It was snatched from him. So exactly also the cause of action is not the same, Lordship. The snatching is also against other persons. The allegations are against other persons as well. So today he cannot make out a case of double jeopardy. At best, he can say that accused number 6, against him double jeopardy may lie, if at all.
Under section 173(8) vis-a-vis 193(9), that point could have been taken before the jurisdiction.
But the complainant is
adding some more accused, some more involved persons, and the facts which were not there in the complaint.
Which were not there in the complaint.
Submit one thing.
Complaint is required.
made by the person, by the husband, by the wife, the earlier complainant. She has made rather the husband of the present complainant. The husband of the present complainant has gone there and said that I do not wish to pursue with my complaint. Information today is being received by whom?
Now today, since this incident which took place
In 2024, 9/9/2024.
9th November 2024. Now, I will permit the authorities to investigate. But where is the necessity of custodial interrogation?
Lordship, the necessity of custodial.
I am not quashing the proceedings. But where is the necessity of custodial interrogation?
Lordship, the necessity of custodial interrogation is because the arms which were used in the view of the statement that has to be recovered.
You serve notice upon the petitioners, he will comply with it, and you investigate the matter.
My lord,
Lordship,
may I just
whether
submit one thing?
custodial interrogation is required or not, firstly, that ought to be adjudicated, especially in view of the fact that a pre-arrest bail application is pending. That is pending. Admittedly, that is pending, and that has been pending for long. And by giving pending anticipatory bail application, a 438 application is pending before the learned sessions judge.
That is one difficulty, that there is.
And he has been showing the pendency of this writ petition before the learned sessions judge to continue to take time.
No.
And avoid the investigation.
My learned friend
That
was not
is
there.
the abuse of process of law.
My lord, may I
Yesterday
just
I was
humbly
present
submit
before
one
he-
thing, my lord?
Before the Niharika infrastructure, it has been specifically observed that there is an alternative remedy available to the accused by moving 438
Lordship,
application.
and
Or
today I am not even quoting any judgment because
482
everything,
application vis-a-vis
Lordship,
438
and everything has to be taken on its own facts. The facts over here are, if I may use the term, dirty.
That is also troubling this court.
It is
In
dirty.
this 438 today, if the court passes an order, that 438 application will become 482 application will become infractuous.
Lordship, 438.
Oh, this is under 438.
No.
BNSS is 482.
Oh, yes, I am so sorry. I was referring to the new section.
That will become infractuous.
That will become infractuous, and this is the exact ploy to get an observation from the Honorable High Court, any observation, so that it influences, like which is being shown today.
My lord, may I just submit one thing, my lord?
It's not required, Mr. Banerjee. You are the de facto complainant.
Yes, my lord. Yes, my
Yes.
lord. Yes.
By presenting this writ petition, comma, inter alia, comma, petitioner has prayed for quashing of criminal prosecution being Khordha police station case number 342 of 2026 dated 26 June 2026. It is submitted that where is the complaint of wife of the petitioner? Based on which
My lord,
It
I have,
must be
it is
there
part of the
with
CP.
my supplementary affidavit, Lordship.
It is part of the case diary also.
Page 23 of the writ petition.
And moreover, while filing this complaint about the earlier case, about the withdrawal of money by the de facto complaint has not been disclosed. Lordship, that has to be produced and considered.
Question is
Nothing has
whether
been
all these
discussed in
things
the
have been
petition.
framed or not by this particular person. Withdrawal has been under threat or not. This is a subject matter of investigation here.
And moreover, let us see, Lordship, in that case, where the money has gone. Because real lottery has already been paid. They have already paid.
One Lokhi Sarkar lodged complaint.
Lokhi Sarkar, wife of the
earlier de facto complainant.
Yes. কি বলছিলাম?
And Lordship, just one point before
one Lokhi Sarkar being the de facto complainant. Being respondent number 5. Lodged complaint on 16 June 2026. Alleging forcibly petitioners alleging by applying force, petitioners took away one lottery ticket
2 years back.
in 2024. Based on which previously
For the PS case number 624.
Please take your seat.
I'm just assisting your Lordship.
You need not assist me. If I require, I will tell you.
Lordship.
Yes. Based on which previously a criminal prosecution was initiated being FIR number 624 dated 14th November 2024, taking note of complaint of husband of taking note of the complaint of husband of respondent number 5. So, there on a there FRT was filed in the previous.
Yes. No, nothing was filed. A statement was recorded and it was kept pending like that.
Lordship, your submission is this, that
FRT has been filed, it has been recorded by the learned court below.
It is submitted that in connection with previous criminal prosecution, in connection with said previous communication, in connection with said previous criminal prosecution, FRT was filed and issue was settled. Therefore, respondent number 5 is stopped from. Therefore, concerned police authorities are stopped from initiating fresh criminal prosecution. Stop. It is further contended that taking this, it is further contended that considering this aspect, one accused in FIR, one accused in Khorda police station case number 342 of 2026 dated 26 June 2026 obtained bail or was enlarged on bail vide order dated 23rd July 2026, passed by Additional Sessions Judge First Court. Reliance is placed on the observations made by Additional Sessions Judge First Court, Barakpur, North 24 Parganas, in order to contain that on same set of facts, initiation of second criminal prosecution is impartial. Stop. উপরে একটা সাপ্লিমেন্টারি এফিডেভিট করতে হবে। সাপ্লিমেন্টারি এফিডেভিট is filed on the petition.
Lordship, kindly sees paragraph 6, closure report filed on 31/12/2024, which is still awaiting consideration of the learned magistrate. Paragraph 6 of the order which my learned senior friend is relying on.
Learned court has not closed it. That's why I am saying
was
it
not
was
the
open.
submission which my learned friend made.
No, আমি বললাম পুলিশ এফআরটি দিয়েছে, কথাটা তো is not same.
Cognizance of that has not been taken. Ought to have pointed this out.
And police could have asked for 173(8).
Police could have asked.
Mr. Das, learned additional government leader representing state correspondents, has opposed this writ petition, and it is submitted that present criminal prosecution being FIR, present criminal prosecution being Kharda Police Station case number 0342 dated 342 of 2026 dated 26 June 2026 is initiated based on complaint by respondent number 5, who was not the complainant in the previous criminal, in the aforesaid previous criminal prosecution. Rather, respondent number 5 is wife of the respondent number 5 is respondent number 5 is wife of de facto complainant in previous criminal prosecution. Stop. It is also submitted that it is also submitted in reference to paragraph 6 of the order of Additional Sessions Judge First Court, Barakpur, North 24 Parganas, passed in reference to passed on 23rd July 2026 on an application on a bail application by another accused, that previous criminal prosecution was not closed based on settlement. Rather, investigating agency filed a closure report on 31st December 2024, which was still which was awaiting consideration of the jurisdictional magistrate. Stop. reliance is also placed on the statement made before the judicial magistrate that is the statement which you are relying upon was made before the judicial magistrate under section 183 statement of the husband of the present petition.
Yes.
In connection with previous
case, why he had to withdraw. So that that is more relevant because it was he who had filed the compromise. Direct evidence, not a hearsay. And Lordship, this order is in a 439 after custody. 438. Today his prayers are for
your contention. He was compelled to compromise.
Yes. And that is what he has recorded.
Lordship, then in that case, 173.8 was open to them.
Made before the jurisdiction, made before the judicial magistrate under section 183 BNSS by the husband of respondent number 5 in connection with previous criminal prosecution, which according to the state respondents reveals that husband of respondent number 5 being the complainant therein was compelled to compromise since petitioners are influential persons. Next paragraph. Having regard to in addition thereto, it is also submitted that petitioners have preferred petitioners has preferred pre-arrest bail application. Both the petitioners have preferred.
No, one petitioner has been arrested.
Who has been arrested?
Titankar Ghosh.
So, pre-arrest bail application by petition number 1, 2.
That is why I am saying, Lordship.
Petitioner number 1 has not filed any application.
Then there are two causes of action. Then let him deposit the deficit court fee first. I will take technical.
Lordship, I have deposited.
ঠিক আছে তো deposit করে থাকলে ভালো.
So petitioner number 2 has filed a pre-arrest bail application, and in the meantime he has been arrested. So that has been the pre-arrest bail application becomes infractuous.
No, Lordship.
That has become
for
infractuous.
One of the writ petitioners, page number 28 of the writ petition, that is the pre-arrest bail application of Nirmal Ghosh, of respondent number 1.
Yes, Lordship.
Of petitioner number 1. Petitioner number 2.
Where from you are reading?
From the writ petition.
Page 28 of the writ petition, Milord.
Page 28 of the writ petition. Page 36 is একটু দাঁড়াও না ঠিক আছে ভালো করেছো খুব ভালো করেছো
তাহলে বুঝছিস কেন?
Page 28 is Nirmal Ghosh. Page 36
there is a
is
bail
Titankar
application
Ghosh.
on the section page 28.
Lordship, in regarding respondent number 2, bail application has become infractuous.
So far respondent number 1 is concerned.
It is on tomorrow. It is on tomorrow.
So
সেটাই তো
why you are saying no, that no
there is no
pre-arrest
bail
application is there? So in
But
connection
Lordship,
with petitioner
if any
number,
negative
petitioner
report
number
comes
2,
today,
in
it
connection
will
with
affect me on tomorrow.
and he wants a positive
so far
resolution
petitioner
today.
number 2 is concerned that he has already been arrested.
And for that, separate application has been moved. That is, I am not on that.
কি বলছিলাম?
But that doesn't improve the merit of the case.
Petitioner number 1,
There is no merit in the case.
I know.
Your case.
It is also submitted that both the petitioners have preferred pre-arrest bail application under section 482 BNSS and same is pending.
No, Lordship. One is infractuous and that has been closed.
Here this court,
Lordship, that has already been infractuous.
Yeah, please have patience to hear the order which is being dictated upon.
No.
কি বলছিলাম? Stop. However, it is submitted on behalf of the petitioner that petitioners that petitioner number 2 has already been taken into custody. Therefore, pre-arrest bail application of petitioner number 2 becomes infractious, whereas pre-arrest bail application of petitioner number 2 remains alive. Stop. Next paragraph. Having considered the respective submissions made on behalf of the parties, court needs to consider whether present writ petition would be entertained, seeking quashing of criminal prosecution being Kharda Police Station case number 342 of 2026 dated 26 June 2026. Stop. By lodging complaint, it is alleged that petitioners committed offense requiring investigation by the concerned police authorities. Stop. However, it is argued on behalf of the petitioner that without reviving previous criminal prosecution, being Kharda Police Station case number 624 of 2024 dated 14 November 2024, initiation of separate criminal prosecution is not permissible. At the same time, it is contended on behalf of the state respondents that though closure report was filed in connection with previous criminal prosecution, but same is awaiting consideration by the magistrate. And to that extent, stop. In the present, in the subsequent criminal prosecution, complaint is lodged by wife of de facto complainant of previous criminal prosecution. Stop. It is also found that both the petitioners are influential persons. Comma, petitioner number 1 is member of Legislative Assembly.
He was erstwhile.
Petitioner
of Panihat.
number 1 was member of West Bengal Legislative Assembly at the material point of time. And petitioner number 2 was
Brother. I think. Brother.
His son.
Chele.
Son.
He was not holding any post. Petitioner number 1 was member of the West Bengal Legislative Assembly at the material point of time. Stop. Contemporaneously, complaint was lodged by husband of the respondent number 5, in November 2024, just after the alleged incident centering around lottery ticket took place. Stop. It is also alleged by the de facto complainant that due to pressure exerted upon her she was compelled to settle.
Her husband was compelled to settle.
Yes.
Her husband was compelled to settle.
Yes. He was compelled to settle. The case, but according to the state respondents, the report is yet to be accepted. Stop. Next paragraph. There is another issue which needs consideration, that petitioner number 1 has filed pre-arrest bail application under which is pending before the additional session judge.
No, Lordship, before learned district and
District judge.
Right.
Pre-arrest bail application. It is anticipatory bail application, which is pending before the appropriate forum.
Learned DCS Barasat 2209.
Stop. Before the appropriate forum. Stop. Next paragraph. When facts are hazy and investigation is being continued based on the complaint lodged by the respondent number 5, this court does not find it apt to interfere with the criminal prosecution which is being carried out.
Lordship, 170
Especially in the context that there is an alternative remedy available to the petitioner under section 482 BNSS, and same is availed of, comma, pre-arrest bail application is pending before the appropriate forum. Next paragraph. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2021-19 SCC 401, Niharika Infrastructure Private Limited versus State of Maharashtra and others.
Then, Lordship, I may be given liberty to file
Paragraph
afresh after pre-arrest bail
33.16
hearing.
Paragraph 33.16 of Niharika Infrastructure Supra Ranks Infra. Paragraph 33.16 টা ইয়ে করে দেবে, কোট করে দেবে। Next paragraph. It was succinctly decided in Niharika Infrastructure Supra that High Court, while exercising writ jurisdiction under Article 226 of the Constitution of India, needs to exercise its power in deciding a writ petition seeking quashment of criminal proceeding sparingly and with circumspection. Stop. It is not a routine procedure to pass order thereby granting protection to the petitioner or to issue mandamus declaring criminal proceeding void. Stop. Next paragraph. In aforesaid conspectus, present writ petition is not interfered with and same stands dismissed. However, this order shall not preclude the petitioner to press anticipatory bail application before the to press pre-arrest bail application before the appropriate forum. Stop. Petitioner shall also be at liberty to rely upon all necessary relevant judgments at the time of consideration of pre-arrest bail application. Stop. Next paragraph. Since this court is apprised that petitioner number 2 has already been taken into custody, therefore, present writ petition seeking quashment of the criminal proceedings becomes infructuous so far petitioner number 2 is concerned. Stop. Urgent Xerox certificate copy. Grateful. This is your
My
case
copy
diary.
of the case.
এটা দিয়ে দাও। Case diary which is produced before this court on behalf of the state respondents is returned back to Mr. Das, learned additional government.
Grateful.
But Lordship, one thing, just it's an academic thing, Lordship. 173(8) is open alternative remedy. Your Lordship is directing me regarding alternative remedy, but this is a case of alternative remedy was open to them as well.
I have passed order.
No, I'm saying, Lordship, that alternative remedy, leave it, it's not.
Yes.
Item number 13.
My lord, item number 13, my lord, on behalf of Bhaskar Chandra Marna, I'm praying for not today, my lord.
He prayed for time. Philosophy accorded him, I think this matter today. Now he has come to this court. Now he has went to the tribunal to do this matter, to earn more money.
Actually, my lord,
Your Lordship, on behalf of state,
Yes,
we have
nothing in
filed
this
a
matter.
report.
On the
Yeah.
same cause of action, 3 writ petitions was
praying
made.
for not today, my lord, in his presence, decide the matter, my lord.
Yes, place your case, Mr. Dotty. You are appearing for the private respondent.
My-
Yes, what is the case?
First of all, the 3 writ petition, first writ petition was moved. Their case is that
By the same petitioner.
same petition. The case is that he has got the patta. Now he is out of possession about 20 years.
Patta holder.
Patta holder. He is about 20 years. BLO filed a report that he is out of possession more than 20 years. Now he has come by a writ order, court's order, he will get back possession.
Give the possession.
He will get back possession. This is.
So he is praying. Oh, yes, that is the prayer. Grant of police help
And
for
is it
peaceful
clear?
possession. Last writ petition, last order is dated 24th September 25.
Fine.
Page 44.
Yes.
Yes. Here the court also say.
Just a minute. Issue. At the time of call, accommodation is prayed for on behalf of the petitioner. Petitioners. But the same is refused since previously hearing of this matter was adjourned on the prayer made on behalf of the petitioner. Stop. On hearing learned advocates representing state respondents and respondent numbers 8 to 13. 8 to 13. It appears that petitioner, for preserving his right over the land in question, filed previous writ petition being WPA 21976 of 2025, which was disposed of by a coordinate bench. Video order dated 24th September 2025. Stop. By said order dated 24th September 2025, by said order dated 24th September 25, or in the said order dated 24th September 25, it was observed as right, title, and interest in respect of property in question, was found to be involved, writ court is not the appropriate authority, appropriate forum. Writ court is not the appropriate forum to decide the same. However, concerned police authorities are directed to keep strict vigil to avoid untoward incidents. So, next paragraph. On perusal of considering case made out in this writ petition, it transpires that petitioner has prayed for direction upon the concerned police authorities which would facilitate the petitioner to have peaceful possession over the property in question. Stop. On similar prayer, previous writ petition was filed and same was disposed of video order dated 24th September 25. Therefore, no further order is warranted on this writ petition. Hence, writ petition is dismissed. Parties to act on the server.
Lordship,
I have not called for any report.
14, my lord, I have the same pair, my lord. 14.
Yes, yes.
Item number 14.
Petition numbers 8 to 14, not 13.
You are appealing for 8 to 14.
Lordship, in the previous matter, Your Lordship, item. But I was dictating the order, my lord, observed 8 to 13, so instead of that 8 to 14.
8 to 14. Hey, দেখে নিও তোরা 8 to 14 হবে বলছে respondents. Private respondents. Yes. Yes, who is for the petitioner? You are praying for time. You are for the private respondent.
Private respondent.
Yes, what is the matter about?
Purely civil dispute.
Civil dispute.
Purely civil dispute.
Filed by the plaintiffs and the defendants where the petitioner is one of the plaintiffs. That suit is still pending, since.
Then I thought that matter will be sent to the
monthly list and then wait for a change.
This petition, he has already admitted that there is no injunction passed by the civil. Kindly see prayer B and prayer E.
Prayer
B and E. Specific injunction he is seeking for. As he is not getting the injunction in the civil court.
prayer B and G.
E.
Issue. At the time of call, accommodation is prayed for on behalf of the petitioner and same is refused. Since previously prayer for adjournment was granted, prayer for adjournment made on behalf of the petitioner was granted and matter is fixed for consideration today. Next paragraph. Learned advocates representing state respondents and respondent number 7 to 14 have opposed this writ petition on the count that issue involved in this writ petition is civil in nature. Stop. Stop. Next paragraph. On perusal of the prayers couched in this writ petition, it transpires petitioner prays for direction upon the concerned police authorities which would facilitate the petitioner to have peaceful possession over the land in question. Next paragraph. If petitioner has if possession of the petitioner over land in question is disturbed, in that event petitioner needs to approach civil court, full stop there. Police authority is not the appropriate authority to decide right of petitioner over the land in question. Next paragraph. Hence, no relief is granted to the petitioner. Writ petition stands dismissed. Writ petition stands dismissed. Parties to act on the server copy. Hence, Hence, present writ petition is not interfered with and same stands dismissed. Stop. However, this order shall not preclude the petitioner to approach appropriate forum in pursuit of remedy. Great.
Item number 15.
50, I am for the petitioner, my lord. This is my affidavit of service.
Who is appearing for bank?
I am appearing for the bank.
My lord, petition.
And state? Who is appearing for state?
Okay.
Have you served?
Yes, my lord.
When served?
Served on 23rd of July 2026.
When you have served notice upon the office of the government leader?
23rd of July, my lord.
23rd July. Show me.
Yes, ma'am. Page 3 of my affidavit of service.
Yes, what is the matter of?
Sir, petitioner maintain a savings bank account of State Bank of India, BKPAL.
It has been debit freezed.
Yes, my lord. Thereafter, my lord, I representation before the concerned police station, and also I made RTI application to the concerned State Bank of India, and on kindly page, my lord, 15, my lord. In RTI application, in paragraph 4, they stated that the amount was put on hold by the centralized cyber cell partner. That is the matter.
What is the disputed amount?
Disputed amount, my lord, 1,21,473. That
disputed amount.
Disputed amount put on hold by this amount. I could not transaction by
amount which is lying in your account is 1,21,000.
No.
It is a disputed amount.
That amount is held by the bank.
That is the amount lying with the bank.
Lying with the bank.
Disputed amount is 23,001.
23,001. Say so. Then let this disputed amount be kept as lien, and rest of the amount shall be operated, and petitioner shall be permitted to operate the bank account.
There are several complaints. There were several complaints. Several transactions happened
on this account.
On this account, I am having all these copies, my lord. So out of that, my lord, bank had no other option but to put a debit freeze, partial debit freeze on the account. And if my lord detects, then obviously, my lord, we will act.
Just pay for defreeze the account.
Yes, the entire account cannot be. The disputed amount, that is Mr. Shah is submitting that it is 23,000.
23,001.
23,001 is to be kept on lien, and rest of the account you will be permitted to operate.
পুলিশ কমপ্লেন্টের ব্যাপার আছে
affidavit of service filed on ভালো কাজ করছো তো affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Client advocate representing the petitioner submits his account maintained with State Bank of India, BKPAL Avenue branch, Kolkata, is debit freezed on the allegation that certain illegal transactions were made on such account. Stop. According to the next paragraph, according to the submissions made on behalf of State Bank of India, in terms of communication, in terms of intimation forwarded by the investigating agency, account of the petitioner is debit freezed, and disputed amount in connection with account of the petitioner is 23,001. 23,001. Stop. Next paragraph. Taking note of the submission made on behalf of SBI or on behalf of bank authority, petitioner shall be permitted to operate his bank account, excluding rupees 23,001, which shall be marked as lien. Next paragraph, with the aforesaid direction, writ petition stands disposed of, parties to act on the subject. Next.
Item number 16.
I'm for the private
Last
respondent number
petition.
7, 8, and 9.
On the last occasion, I submitted that I called for record from Debra police station, which inaction this case. But till today, despite of thrice called on him, they did not come for giving report.
No, instruction has come.
Okay.
No.
তো আমাকেই তো দিল GP office থেকে।
Yes.
My case, your lordship.
You are for the private respondent.
হ্যাঁ, এই তো।
I'm for the private
So
respondent.
you haven't received instruction.
The instructions are here. I believe.
He says he appears,
My lord,
but we
I
have
was
instruction.
instructed to appear and I have the instruction.
But we are appearing on behalf of the state.
Last occasion also.
Yes.
My lord, I take two of my representations. My lord, kindly come to page 69. That's the case. I cannot make better than this.
ঠিক আছে।
My lord, I am for enforcement of my personal freedom and liberty as a fundamental right. Page 69. My lord, the first paragraph, I describe myself, who am I? Then your lordships. আমার বিনীত নিবেদন এই যে দেবরা থানার অন্তর্গত মৌজায় জেল সাচ এন্ড সাচ নাম্বার জায়গা আমাদের নামে রায়ত রেকর্ডভুক্ত আছে। ওই জায়গায় নিম্নলিখিত ব্যক্তিগণ জোরপূর্বক দখল করার চেষ্টা করছে, তা নিয়ে আমার জায়গা উপর কেস করি, যার কেস নাম্বার সাচ এন্ড সাচ মহানন্দালে বিচারাধীন অবস্থায়।
WBCRC, before which authority, before which forum?
My lord, one is pending before this honorable court.
Acha. Yes.
My lord, this is I'm not banking upon. This is a dispute in that. বর্তমানে নিম্নলিখিত ব্যক্তিগণ আমাদের উক্ত জায়গা তাদের নামে রেজিস্ট্রি করে দেওয়ার জন্য নানাভাবে চাপ সৃষ্টি করে। আমরা তা না দেওয়ায় উক্ত ব্যক্তিগণ গ্রামে আমাদের একঘরা করে সামাজিক বয়কট করে রাখে, আমাদের বাজারঘাট যাওয়া বন্ধ করে দেয়, ছেলে মেয়েদের স্কুলে যাওয়া কার্যত বন্ধ করে দেয়, যখন তখন আমাদের বাড়িতে চড়াও হয়ে উক্ত জমি তাদের নামে রেজিস্ট্রি করে দেওয়ার জন্য চাপ সৃষ্টি করে। But I am on this. There are several other representations. Each event I have described, your lordships will find. If your lordships kindly come to page 71. I cannot cultivate my land. I cannot take my children to the school.
Where from which this ordeal is taking place is happening.
This is, my lord, from just after my lord, his representation is made on the 6th June. It's from the June.
This case, my lord, dates back.
My lord,
I'm subject to one.
My land case, I am not on
I am
that.
sorry.
Land case long before.
Yes, that is what I was indicating.
That's I'm not urging before your lordships. Whether I am urging only my personal liberty and freedom, whether I can take my children to the school, whether I can take my wife to the hospital.
You cannot take your children to school.
No,
You
because
cannot cultivate.
No, I can cultivate, but just because I have not given the land. That's the reason. But I'm on the action. The medical shops are threatened if they don't give me the medicines. Then what should I go? How should I go? This has to be enforced by the police.
Then, my lord, let the person who is running the medical shop be made a party. Let the school be made a party.
You are representing.
My lord, I am representing 3 private respondents. But they are the persons against whom they are alleged that we have a land dispute with them since 2009. My lord, this land dispute is carrying on. Now, my lord, what I believe, my lord, that land dispute is one issue, which is the second issue is the current scenario where they are saying there is a social boycott. But that is what I understand, my lord, from the petition. Now, my lord, with regard to the social boycott, my lord, I don't ostracized, my lord, ostracization, my lord, I leave it to your lordship's wisdom, my lord, how, my lord, this court, my lord, would deal. Secondly, my lord, with regard to, my lord, the, my lord, representation which has been made, my lord, that whether it tantamounts to a cognizable offense, my lord, the police office, as your lordship knows, if this is not been acted upon, 175(3) can be acted upon.
Petitioner is making out a case of violation of Article 21.
Well, Article 21, my lord,
issue.
my lord, they are saying,
I cannot take my children to school.
Right, my lord.
I cannot cultivate.
My lord, right, my lord.
What is
Yes.
My lord, I have a categorical instruction from the police authorities. My lord, before submitting that, my lord, I beg to submit that every offense or every criminal offense has a genus, and here the genus is actually starting from the year 2009, my lord. There is an issue of civil dispute, my lord. Civil suit has been pending, my lord. Thereafter, they withdrew. My lord, an unauthorized construction is going to be constructed at that point of time. My lord,
When?
My lord, 2009, status quo order was there. My lord, thereafter, some of the issue was resolved. thereafter the same issue has been going on. If we look the records, it appeared from the LR records, the every record speaks that the property is for সাধারণের ব্যবহার্য, it stated in page starting from page 46, it ends in page 50, they are stating that we are the absolute owner of the property stated in para 1 of the writ petition, and from page 46 to 50 it says that it's the Pirostan সাধারণের ব্যবহার্য. So they are not the, what I am trying to establish before your lordship that this is the genus of the dispute is absolutely civil.
Genus is polluted. That doesn't mean I will lose my right.
It transferred from the report also. It transferred from the report also, my lord. We initiated 107 proceedings, my lord.
107 proceedings have been
initiated, my lord, and yes, my lord, even an FIR was registered, but not with the BS of that complaint, my lord. And so far, the point of social ostracism is concerned, my lord, the categorical instruction of the police authorities, my lord, he is threatening to each villagers that we will take a lesson and go to court against you. The threatening for initiation of criminal proceeding against each other. One of the person was registered at Debra police. হ্যাঁ এখানে দিয়েছি। Next with the the writ petition also.
না আমি বলতে চাইছি বলা আছে অ্যালিগেশনে বলা আছে আমি সেই ভদ্রলোকের নামটাও দিয়ে দেবো আমাদের সঙ্গে আপনি
এটা private respondent.
But your prayer is otherwise.
Yes.
Come to prayer A. Prayer A. Consideration of your representation.
That is what I had.
Strictly in accordance with
175(3) then.
For registration of FIR.
Direct the respondent police authorities to register appropriate criminal case.
Yes.
Yeah, that is what I
prayer
had.
B also
Yes.
prayer B also
That is what, my lord, your lordship. Now 2026 judgment.
Prayer E.
prayer B
B. Yes. To register appropriate criminal case.
Yes.
Prayer B.
prayer B
How that is permissible before this court? You have to approach jurisdiction magistrate under section 175(3).
all that prayer can be molded in the
Yes, sir.
So judgment can.
May I have a copy
Heard
of
the
the
learned
report?
advocates representing the petitioner, private respondents,
May I have a copy of the report?
and state respondents. Yes, state respondents. You will get it.
Kindly let me go through
No,
and come back,
no.
your lordships.
State respondents.
Unless I deal with that, how can I?
State respondents. Stop. Learned Mr. Subish Sharma, learned senior advocate representing the petitioner, submits that though there is a dispute over property in question, but at present petitioners are subjected to social boycott, thereby prompting the petitioners to approach this court with the present writ petition, seeking necessary direction upon the concerned police, which would facilitate the petitioners to lead normal life. Next paragraph, Mr. Moyuk Mukherjee, learned advocate representing respondent numbers, private respondents, and the learned advocate representing state respondents have jointly opposed this writ petition. Stop. It is submitted that core issue involved in this writ petition is dispute over property / land in question, requiring the petitioner to approach the appropriate forum. Next paragraph, having considered the respective stop a communication dated 27 July 26 of officer in charge Debra police station is filed today and same is taken on record. Copy of the said communication dated 27 July 26 is made over to the learned advocate representing the petition. Okay. Next paragraph, having considered the respective submissions made on behalf of the parties and taking note of the contents of the communication, this court finds that there was a dispute over property in question, and if petitioners find his right over the property in question is breached by acts and actions of private respondents, in that event petitioners are required to approach the appropriate.
No, I am not praying that. Your
Next
Lordship.
paragraph. In addition thereto, a case is made out that petitioners are subjected to social boycott. Stop. In this regard, concerned police authorities are directed to to provide assistance if occasions arise. Stop. Writ petition stands disposed of. Urgent xerox of application.
I was appearing for state in the matter.
Most obvious to your lordship.
Thank you, Indra.